So before we starting with the mock interview, I may introduce to the candidate to our mock panelists. So our panelist number one is Sir Sri Goyadhar Panda, who is a retired district judge and is also was a legal advisor to the state vigilance. Also, he is teaching to the OJS aspirants and many other law students for since last 10 to 15 years. So, and we have with us Dr. Pallab Das, who is the Dean of Centurion School of Law. He was also a judicial officer. So, thank you both the panelists for joining with us today. Sourav, you may uh, turn on your camera. I request Gadar Panda sir to take the interview on board.
Yes, Sourav, good morning. Good morning. Do you know under which law civil judges are appointed?
Sir, I don't know the exact provision for appointment of civil judge.
Okay. What is the hierarchy of civil judges, particularly in subordinate courts, in civil side?
Starting from the bottom, first come the civil judge junior division, then civil judge senior division, then district judge.
Who hears the first appeal against the judgment of the civil judge senior division?
The district judge will hear the first appeal against the judgment passed by civil judge senior division.
Then what is second appeal?
Second appeal is preferred to the High Court on the question of law.
Can the High Court decide an issue on facts while deciding a case in second appeal?
Generally, High Court decide a case on the substantial question of law, uh, but the court can go into the fact.
What is an appealable order?
The order which are mentioned under Order 43 and Section 104 of the CPC are appealable order.
Please give example one order which is appealable.
An order passed for cost under 35 is appealable.
Only 35.
35 and interest under on 36, and there
When the
are
court,
other provisions.
okay, when the court directs for payment of interest while passing judgment,
The court can give a order to pay interest of 9% while passing a judgment when the sorry sir, I don't recall that provision.
if court can direct payment of interest beyond 9%, if so, in which case? Not 9%, beyond the agreed rate of interest.
Sir, I don't know the case law.
One party obtained an injunction order without any ground. The defendant filed petition before the court that compensatory or damages should be given. Will it be allowed?
Yes, if the injunction is passed without any ground, then the party against whom it was passed, he can claim compensation.
Is there any section to that effect? You are aware if there is any provision in the civil procedure code.
Yes, there is a provision under 95.
Is there any provision in the CPC for public interest like public interest litigation?
um, under section, there is no exact term like public interest litigation in CPC, but with similar type of provision such as representative suit or under section 91 for it can be filed.
What is representative suit?
Uh, when a person on behalf of several person with their permission or under the direction of the court file a case or under the direction of court he defend it, then it is a representative suit. It is mentioned under order 1 rule 8.
Is there any provision in the civil procedure code in any law that a court will direct somebody to file a suit?
The
Your answer
court
is
can
that as per the direction of the court. Direction of the court, a suit
the
cannot be filed.
the court can direct any person to defend a suit
Is there any time
on
limit
behalf.
for filing written statement? Is there any time
Written
limit for
statement
filing written statement? No.
written statement are filed 30 days from the date of receiving of someone, which can extend to 90 days.
Suppose the defendant did not file written statement in a case. What the court will do?
The court can set him ex parte.
Why the defendant is appearing but did not file written statement? Why you expect will be set? What is whether a judgment passed ex parte is appealable?
Uh, yes, it can be appealable. Ex parte decree can be appealable.
Okay. What is res gestae?
There are some facts which are though not in issue, but it form a part of same transaction. So these type of facts are relevant whether it occurred same time or place or different time or place. This is called res gestae.
What is leading question?
The question suggesting answer is called leading question.
When that leading question can be asked?
Leading question are asked in cross examination.
Only in cross examination. Can such leading question be put? Is there any provision for putting leading question in examination chief?
Yes, and there are provision for putting leading question if the opposite party doesn't object. It can be put. And
What is
if
re-examination? What
the
is re-examination of a witness?
after completion of the witness by the adverse party, the party calling the witness can examine the witness. This is called re-examination.
On which point there will be re-examination?
The point rise in cross-examination, the re-examination will stick to that point, but new fact can be introduced at the time of re-examination. But in that case, the opportunity should be given to the adverse party to cross-examine on that point of law or on the point raised in re-examination.
What is mischief in IPC?
uh, when a person, in order to commit some wrongful gain, destroy the property or cause some act to diminish its value, then this is called mischief.
If by committing mischief somebody will get something, there will be a gain property.
No, there is wrongful loss to a person, but the offender may not get something in return.
What is wrongful loss?
The wrongful loss means when a person uh, uh, lost something which he has legally entitled to.
Tell me an offense where there must be a wrongful gain or wrongful loss. In which offense there must be?
In theft, there is a wrongful loss for one and wrongful gain to the other party.
Who will be a second class judicial magistrate? Which offences are triable by the second class judicial magistrate?
The offences which are punishable with imprisonment up to 1 year are tried by judicial magistrate second class.
Is there any specific law to that effect which provides that those offences are to be triable by the second class judicial magistrate?
There are provision in CRPC which tell about the jurisdiction of different judges and magistrates.
A magistrate first class tried a theft case. That is triable under the warrant procedure. A charge should have been framed. But inadvertently, charge was not framed and the accused was convicted. Thereafter, the convicted accused preferred appeal, challenging the conviction and claimed for acquittal as there was no framing of charge. Whether the appellate court will acquit that convict?
The, the appeal in warrant cases, the framing of charge is mandatory. As the theft is come under this warrant case, then the appellate court can acquit the convict on that basis.
What is criminal division?
When under section 397 to the 401, the provision for criminal division is laid down. The High Court and the Court of Session and additional session judge has power to criminal division. It is stick to the point that whether the court below has follow the proper procedure of law or not.
Can the magistrate first class grant bail in a case which is triable by the sessions judge?
The magistrate first class cannot grant bail with a offense which is triable by a court of session.
What is your opinion regarding uniform civil code? Whether it is necessary?
Uniform civil code is a progressive state not only for the gender discrimination but also for cooperation of different community within the society. And as there is no fundamental rule, but it was laid down in the DPSP of the Constitution.
What do you mean by a secular state?
The secular state means the state has nothing to do with the religion of the people. They are independent to follow any religion.
Can this preamble be amended, deleting the provision of secular states by the parliament?
No, no. The word secular state, secularism, each comes under the basic feature of the Indian Constitution. So the basic feature cannot be amended.
Basic feature?
Basic structure.
What do you mean by basic
Secularism.
structure? What do you mean by basic structure?
The parliament has power to amend the constitution, but it can amend some basic feature, which such as supremacy of
You are
judicial
confused. Sourav, you are
structure.
confused what is basic feature and what is basic structure. You are confused. What is basic feature is something different, and what are the basic feature and basic structure? You are confusing yourself. Okay. Thank you. I will give you the feedback after your interview by the second panelist. Thank you.
Thank you, sir.
Good morning, Sourav. Could you please
Good morning,
introduce
sir.
yourself?
My name is Sourav Mahapatra. I have done my schooling from Saraswati Shri Mandir, Bargarh, and plus two from Vikas Junior College, Bargarh. I have completed my 5-year BA LLB course from Mosudar Law College and LLM from that Mosudar Law College in criminal law specialization.
Okay, so what are the stages of examination in criminal law?
First, the accused gave a chance to plead guilty. If he doesn't plead, sorry, sir, sorry. Can I start from the beginning? I don't understand the question. First, each examination in chief by the then the cross examination, then re-examination.
And that's it. Is there any other thing apart from examination in chief, cross examination? Is there any other stage after that? Is there a re-cross examination and re-cross examination? Is there a concept like this?
There is no exact provision for re-examination in any statute, but if the court permit, then after re-examination, then the party can ask something which are new and it is introduced in re-examination.
Okay. So, at what stage can new evidence be introduced in a civil suit?
Before conclusion of the trial, the new evidence can be introduced at any stage of proceeding.
So, can additional evidence be adduced in an appeal? New additional evidence?
If the party is satisfied of the court that after exercise of due diligence and that evidence cannot come to his knowledge, the new evidence are introduced even at the time of appeal.
Okay. So, what is the doctrine of subrogation?
The doctrine of subrogation means putting into someone's putting into someone's suit. It means it is the type of substitution.
So, and which provision does it talk about? And in which act do you find the doctrine of subrogation?
Section 92 of Transfer of Property Act, that someone paid the
Okay.
mortgage and
Right. Okay. What is the doctrine of marshalling?
marshalling means suppose a person mortgage some property to another person and subsequently mortgage some property which is mortgaged to prior mortgage to a subsequent mortgagee, then the subsequent mortgagee can tell that the you can recover the property which is not mortgaged to him. From the rest means from the rest of the property we can recover it.
Okay. What is the maximum time limit for an appeal in a civil suit?
90 days.
And what is the easementary time period for a property before which the government can take in the property?
Uh,
You know, limitation.
is
Limitation.
like
I'm talking about the limitation.
30 years.
And for a private property to have possession over that particular land, what is the time frame?
It is 12 years.
What is escheat?
The if a interstate doesn't have class 1 hair, class 2 hair, agnate or cognate, then the property will be taken by the government. This is called district.
Under which provision?
Under the 29 of Hindu Succession Act.
Okay. Is there any provision where a Sapinda relationship can also marry in Hindu Marriage Act?
Yes, if the custom permit, then the party within the subordinate relationship can marry each other.
Okay. What is the capital of Germany?
That I exactly cannot recall. That is
Okay. Who is the Attorney General of India?
Venkatramani.
Honorable Venkatramani. Okay. Who is the Advocate General of the state of Odisha?
The senior advocate of Ashok Parija.
Okay. Who is the Law Minister of Odisha?
Jagannath. Don't know the title.
Okay. Who is the Governor of the Reserve Bank of India?
Shaktikant Das.
And what do you think is the present status of the Russian versus Ukrainian war that is going on?
Sir, I don't know the present scenario right now.
Who is the president of Ukraine?
Zelensky.
Sorry?
Zelensky something.
And who is the president of Israel?
Benjamin Netanyahu.
Okay. And recently, Maldives have, Mauritius has re-elected their president. What was the statement that the Mauritius government made regarding India?
Sir, I don't know.
Who is the father of the Green Revolution in India?
Swaminathan. Dr. Swaminathan.
Okay, okay. And why do you want to join the judicial services?
And I have practiced few months, and I realized that I can serve people in a better manner uh, um, by become by joining judiciary rather than in litigation. I feel that.
Okay. Who is the present Chief Justice of Odisha High Court?
Dr. B.R. Sodangi, elected Chief Justice of Odisha High Court.
So there has been no designated Chief Justice of Odisha High Court right now.
No, a recommendation has been made for appointment, but it was not confirmed yet.
No, he's already been appointed. He hasn't joined yet. Okay. All right. So I'll just give you a little bit of feedback before ending this particular mock interview. Sourav, the first thing is that you don't appear to be confident. You know the answers, but you don't appear to be confident. So that is where you will lose a lot of marks. You need to appear confident. You were told that today you have the mock interview, right?
Yes, sir.
So you should have prepared, dressed up well. You should have had a coat, a tie, and you should have come before the panel. You would have thought that this is your actual interview that is going on. So you should have prepared well in terms of
Yes, sir.
presenting yourself. Knowing the laws, knowing the general knowledge will just not help you unless and until you present yourself in a proper manner. Right? So whenever you say, you need to be very confident when you say. You appear to be, what is doctrine of subrogation? If I ask you, start with the fact that the doctrine of subrogation is under section 92 of the Transfer of Property Act, and it talks about so and so and so. It appears that as if you are thinking what you are guessing what doctrine of subrogation is, what is doctrine of, you did not tell me which provision is doctrine of marshmallow, right? So these are some of the areas where you need to work upon, right? You are not well aware of the general surrounding news. Please understand that it will not just be legal questions that will be asked to you, there will be general questions that will be asked to you. So you need to prepare yourself accordingly, right? So if you have the time before the interview, please go through the general knowledge, the recent one. I'm saying what happened last week in you know. One second, one second. Right. So yeah, that's all from my side, the feedback. But I just want to say that you must appear confident. That is what is lacking. Please sit straight. Sit straight, absolutely straight. Yes. Put your hands on your thighs and appear to be very confident. Don't sit lethargically. Don't put and relax like this. You need to be very straight. Put your hands on your thighs. Put your legs straight or cross-legged. That's all. That is the demeanor. Okay? Appear confident. Whether you know or half of the battle is won if you appear confident. You have the knowledge of the laws. You need to build up on the general side of the knowledge and on your bodily language, bodily postures. That's all. All right? Work on that.
Yes, sir.
Please go in front of the mirror and sit down. Take a chair and sit down in front of the mirror and see how confident you look like. You might not be very good at speaking English. That's all right. I'm not very good at speaking in Hindi. That's all right. But you need to appear confident. Okay. All right. All the best. Over to the organizers.
Thank you.
Okay, Sourav, now I
Sir.
want to give you some feedback. In your previous interview, you have improved better. From your previous interview, what you gave the other day, your interview is better. But always be confident. What, what as advised. Civil judges are appointed under the Orissa Civil Code Act. Orissa Civil Code Act, under that, a civil judge of subordinate courts are appointed. There are three types of judges: civil judge junior division, civil judge senior division, and district judges. Civil judge junior division includes additional civil judge junior division. Civil judge senior division includes additional civil judge senior division. District judge includes additional district. The powers of magistrate, chief judicial magistrate, assistant session judge, additional session judge, are vested with these officers by the Honorable High Court. So the initial appointment is civil judge junior, that you should know. Second appeal is the appeal only on point of law after first appeal in a civil case to the High Court. When the High Court will decide an issue basing on fact, what is totally a perverse decision is there, or some evidence is there, but a fact has not been decided. Very limited cases. The Honorable High Court can also go to the fact, decision regarding fact. Appellate order, you are correct. Order 43, better order 9, rule 9, order 9, rule 30. Remember these two. So far as interest is concerned, that is different thing against the judgment. Interest is given only in a money suit. No other suit on money suit than interest is given. That is maximum, not 9%, 6%. But beyond that, when there is a contractual sale. Contractual scale in commercial transaction. What is contractual scale? If a 12%, 13%, not exceeding that contractual scale. If no contractual scale, not exceeding the rate of interest in which money is lent by the scheduled bank. That you should know. Compensation for injunction, there is a particular section, unnecessarily arrested, a injunction is issued, for that compensation can be given. On the application, so much of the court will not give such compensation. Public interest litigation, there are two provisions, that is removal of public nuisance and for enforcement of public trust. 92, 93 of the SCPC. That will see. 92, representative suit, when a suit is filed on behalf of numerous persons, that is called a representative suit. Or against a numerous person representing, being represented by some persons, that is called representative suit. For an example, there is a dispute regarding a cremation ground between two villages. All the villagers are parties. So in such case, 2 or 3 persons of that village may file a suit, institute a suit representing all the villagers, or against all the other villagers being represented by 2 to 3 persons. That is called representative suit. In such case, notice, if practicable, notice will be given to all the persons. If it is not, then at the expense of the plaintiff, a notice is to be issued, published in the newspaper widely circulated, inviting the parties to join in this suit, who has any interest in this suit. That is representative suit. Time limit for WS initially 30, that can be extended. Defendant did not file written statement. That is, a suit can be, the defendant can contest the suit, only remaining absent than expert. Without filing written statement, defendant can contest the suit. Expert judgment is also applicable. Res stay, fact not in issue, though not in issue, but forming the part of the same transaction. Like that, the example that suppose X is facing trial for committing murder of Y, whatever X, that is X stated or bystander stated, those are not issues in the case, but those are fact of the same transaction. So connected with the fact in issue. Leading question, so a question in which suggesting answer, that is leading question. Only it is put only cross-examination. If objected, it cannot be put in examination chief, but it can be put in examination chief with the permission of the court. Re-examination of a witness after the examination chief and cross-examination, again that witness is examined by the party who has brought him. That is called re-examination. Re-examination is always made to explain certain matters brought in the cross-examination, or if a new fact is introduced, there will be further cross-examination on that matter. Then IPC mischief. On the other day, probably I had asked this question to you. Whoever intentionally or knowingly causes any damage or destruction of property of public opinion, there is no wrongful gain, no loss. Simply damaging property of intentionally causing destruction or loss to that property, that is mischief. So offense at act or omission punishable by law is an offense. Second class judicial magistrate tribunal, any magistrate. In the schedule, the offences which are triable by any magistrate, that can be tried by the second class magistrate. In the CRPC and the schedule, it has been provided. Without charge, if it the 464 of the CRPC, that will not vitiate the trial if that will not cause prejudice to the accused who has faced the trial. This error or omission in charge will not vitiate the trial unless there is material that will prejudice the accused. That means the accused has not cross-examined on that, but not aware. Criminal division, the High Court of the Session Law may call for the records of the inferior criminal court in order to satisfy regarding the correctness, legality, or propriety of any order, findings. That is criminal division. Magistrate cannot grant bail in sessions of trial cases triable by the Court of Sessions because the magistrate lack the jurisdiction to give such bail. UCC, your opinion may be, many opinion may come, but at least you may give one opinion that Uniform Civil Code, there is a DPSP provision is there, Article 41 perhaps, 44 perhaps it is there. Then That will bring unity and integrity of our nation. Only this is unity and integrity of the nation. To promote secular state. State has no religion. State has no religion. State will not encourage any religion. That is secular state. Thank you. So go with confidence. Again, if you do not know a particular answer, very politely, just give your answer, or I do not. Thank you.
Thank you, both the panelists, for your valuable guidance to our candidate. Sourav, you may leave now to the candidate.